One of the biggest estate planning myths that I hear is, Russell, I need to get a trust so that my family can avoid probate. The answer is, well, maybe. But if their question is just, I want to avoid probate, there are several ways to avoid it without ever creating a trust. Hello and welcome back to the Retirement Experience. I'm Russell Slack, the founder of Guided Seasons Wealth Advisors. First, let's discuss that probate isn't bad everywhere. In some states like Idaho, probate is relatively simple and it's inexpensive and over in just a few months. In other states, probate can take years and cost thousands of dollars. And in some cases, even the attorney may bill based on a percentage of your estate's value, which would increase costs substantially. So before anyone tells you that everyone needs a trust, let's first understand what probate is and why it exists. Then we will discuss several ways you may be able to reduce or even avoid it without a trust. So probate, it's simply the legal process of settling someone's estate after they've passed away. The court generally helps accomplish this in several important ways. The first of which, it may verify that the will is valid and identify the executor. Second, it gives authority for that executor to sign legal documents on behalf of the deceased. And third, it provides a process for notification to legitimate creditors. Only after debts and taxes and administrative matters are settled that the remaining assets can be distributed to the heirs. So probate isn't some punishment, it serves an important purpose. The question becomes, can all or some of our assets legally pass outside of that process? And many times the answer is yes. It's true that a revocable living trust is an excellent estate planning tool, and it can provide privacy, it can help avoid probate entirely, and it allows you to control distributions and may simplify things for your family. But what many people don't realize, in many cases, careful planning can eliminate probate without ever creating a trust. And the first way to do that is through beneficiary designations. Accounts such as retirement accounts and life insurance and some investment accounts, they transfer directly to the person that you've named as a beneficiary. And it may surprise people, but the beneficiary designation actually overrides your will and trust. So if your will or trust says one thing, but your beneficiary form says another, the beneficiary usually wins. And one of the biggest mistakes I see is that people set their designations up at the beginning of opening an account and they never update them. So even after a divorce or a remarriage or a birth of children, they never get those things changed. For my financial planning clients, a 5-minute review every few years can prevent major problems by ensuring that wishes and estate planning remain aligned to the beneficiary designations. The next thing is you can also use rights of survivorship. Is your home currently owned jointly with your spouse? Well, when property is owned jointly with rights of survivorship, there is no need for probating a deceased spouse or to make a deed change. Ownership automatically transfers to that surviving owner. So no probate is required for that ownership interest. And this is commonly used again by married couples for homes and some certain financial accounts. Now, the next item is, despite its funny name, a ladybird deed. In some states, a ladybird deed allows real estate to transfer directly to your heirs while allowing you to maintain complete control over the property during your lifetime. Not every state allows them, but where they are available, they can be an excellent probate avoidance strategy without placing property into a trust. Okay, the next one is a transfer on death or payable on death designation. It's also available by many financial institutions, and it's most commonly used on non-retirement brokerage accounts or on bank accounts for non-spouses. That means that when you pass away, the account transfers directly to your named person without going through probate. It's one of the simplest estate planning tools available. Now, none of this means that trusts aren't valuable. They absolutely can be. If you own property in multiple states, have a blended family, want control over how children receive inheritance, or maybe even have a special needs child, a trust is one of the best planning tools available. The point isn't that everyone needs a trust or no one does. The point is that everyone needs a plan. And the right plan helps to ensure that your wishes are met. Now, the biggest mistake that I see is people do no planning at all. They had no idea that they disinherited children or abandoned a spouse. They left things unattended or undone for years, risking their wealth to go to the wrong places. Now, if you remember nothing else from today's video, remember these few things. Keep beneficiaries updated. Own property correctly. Use TOD and POD designations when appropriate. And if your situation is more complicated, consider whether a trust is the right solution. And all of this can save your family months of stress and potentially thousands of dollars. Find a competent, comprehensive financial planner that can guide you in how to ensure your legacy wishes are fulfilled. And if you found this helpful, like and subscribe to stay informed on other simplified retirement planning topics. And until next time, be well.